and I teach law of contract. And in my opinion, of all the 4 law subjects that you'll be doing for year 1, that I think that the law of contract will be your favorite subject, the one that you'll find most interesting and most exciting. But of course, I'm biased, right? But when I say that contract law is interesting and that you enjoy or find most relevant, it's primarily because the law of contract would be likely the subject that will be able to relate to you and to me in a very personal way, because we all make contracts every day. Now, when I say that we make contracts every day, it's true, isn't it? That if you had, say, bought breakfast this morning, you have made a contract. Currently now, you have a broadband service, you have a contract. Over the weekend, you may buy a pair of shoes, you go for a haircut, you've made a contract. You take a train or a bus, you've made a contract. And so we are surrounded daily with contracts that we all make. Now, the examples are given, obviously, the so-called simple contracts. We are familiar with the other types of contracts, the more serious ones. For example, many of you are working, perhaps, and you have a contract of employment. That's a contract, right? You have insurance policies. That's a contract. In case if you are married, in some sense, isn't that also a contract where the 2 parties together signed before witnesses, before an official, the registrar of marriages, to sign to say that we want to be in a covenant, to be in a contract together for life? Even a marriage, in a sense, has its basis in contract law. And so to the extent that's why contract law is the one subject that many of us are able to relate to, right? As I start off with contract law, I want to just take the next 20 minutes to showing you an overview of the syllabus. And if time permits for me now to even go on to share a bit more on one segment or one specific part of contract law, in the hope that at the end of this 20 minutes that you would have learned something useful regarding contract law. So for example, starting with the syllabus, you find that there are 4 main parts of a syllabus. The first part is where we talk about formation of contract, where there will be 4 separate chapters or subtopics within that, where we want to understand and examine what are the requirements to form or to make a contract. So for example, of an immediate question that may come to mind is, must a contract be written? Give it a thought, assuming now that it's a verbal agreement you have with someone over the phone to say, okay, I agree to do the job for you. Is that a contract? Right? So verbal agreements binding. What are the requirements for the formation of contract to make it a binding agreement, to make it a binding contract? Beyond just a handshake, right? What would it take in order for it to be formed a binding contract? And so we will spend 1/3 of the syllabus, a bit lesser of our time, on this area of formation of contract. The second part of our syllabus, and there are 4 parts, will be concerning now this issue or this area of what are the contents of a contract, what are the terms of a contract. So you can see how we are like moving deeper into the syllabus. We started off with examining what would it take to make a contract. Now it's more of what does a contract say? What are the contract terms? Who decides what are the contents of a contract? Now, of course, we know that, and we refer to this T's and C's, right? Terms and conditions. And we sign. And you say, well, once you sign, once you put a tick, you are bound. You are bound, and those are the terms. But is that the case? Have you not experienced this? That, say, for example, in the case of a software update, in the case of where you're going through an online portal and they ask you to read the terms and conditions. Say you want to update, right, your application or software, and they ask you, right, to read the terms and conditions, and then you are given an option to tick either I accept or I don't accept. Do you all, by the way, do you all read all those terms and conditions? I don't think many people do. Why is it that we don't read? Now, sure, you may say, well, David, I don't understand. No point that I read something I don't understand. But no, I don't think that the reason why you don't read is because you don't understand. You don't read for the same reason why I don't read. And the reason why I don't read is because it does not make a difference. I have to click yes, I accept to begin the download to proceed to the next page. You have no choice. In some sense, to put it very bluntly, the vendor, the service provider, they are forcing us to accept the terms and conditions if you want that service. And so I'm thinking to myself now, why bother reading when I have to accept? So I click yes and I move on to download, right? And we don't think too much about it. But if you were to try to read next time, right? You try to read the terms and conditions, you may realize that some of the terms and conditions are pretty onerous. For example, they say things like, we shall not be responsible for any injury that you may suffer whilst using our product. So take an example of a product sale. You buy a hairdryer, you buy a TV or something to the effect like that, and there are some terms and conditions. They came along with the invoice, they came along with the delivery order, and again, we don't read, right, do we? We take delivery of the TV, it's installed properly, the channels work, we sign, that's it. But again, if you were to read, there may be perhaps some disclaimer clause to say we are not responsible for any defect that may arise from this product. Now, so when something goes wrong, and when you do want to pursue legal action, can you? Or are you now bound to the terms of a contract? Now, let's look no further, but a simple case of, say, for instance, our Singapore Universal Studios. A theme park, right? If you had gone to any theme park, and I'm sure that you have seen this, that just before you take that ride, especially the dangerous ones, at the roller coaster ride, what do we see? And we see now a poster, a disclaimer saying, take this ride at your own risk. We shall not be responsible for any injuries that may arise whilst you are taking a ride. You may die, too bad. I know the last part is not there, right? But the point is, they are very clearly putting in a disclaimer clause to saying that we're not responsible. You park your car at a car park, same thing. They say, and the famous line we see in a car park, that poster, right? Park your car here at your own risk. You may go back to the car park, all four tires are gone, park your car at your own risk. You go back to the car park, your car has been stolen, park the car there at your own risk. Vandalized, graffiti on the car, on your car, park your car at your own risk. And it seems to be that because of the terms and conditions, you can't sue. Is that really going to be the terms of a contract? And so part of our syllabus will involve a study of and analyzing or understanding of what the law says governing the terms of a contract. What are our rights? Can we object to say that, hey, that's an unfair term and unfair terms are prohibited in contracts? Can we say that? What about then the other balancing competing argument? That on one hand, as a consumer, as the customer, so to speak, yeah, we want to assert and challenge unfair terms. But what about then the interests of the other party? From a business point of view, they will say, willing buyer, willing seller, freedom to contract. And I need to protect my business interests. I cannot be exposed as a business to infinite, indefinite, indeterminate liability. I need to manage my risks. I need to put in a disclaimer. Yeah, we get that. So how does a law strike a balance between ensuring that customers are protected as that of the interests of businesses? How then do we come up with this position of understanding what can be within the terms of a contract? This what this part of the syllabus is about, the terms of a contract. The third part of our syllabus will involve this area called enforceability of a contract, as in, how do we know whether would the contract be enforced, especially where when something goes wrong and we want to try to find a loophole out. I think it's true, right? Many of us, that we have signed the contract. The contractual terms are very clear. We have read all the terms of a contract. So right now, it's not dealing with the first part of the syllabus, the contract is formed. It's not the second part of a syllabus, the terms are clear. It's the third part. we don't want the contract to be enforced. We feel as if the manner in which the contract was made might not have been perhaps above board or proper. So take, for example, now this picture that you're seeing here now, which of course, it's not going to be one that allows you a successful legal action, but you get my point, right? That in the course of the making of a contract, it's not infrequent that the vendor or the seller may over-promise and under-deliver. You did not get what you saw. Now, of course, in this picture, it's just an advertisement. I get that. For sure, you go to McDonald's, you order that juicy burger online, you may not get the juicy burger when delivered or when you collect it. And so you may feel cheated perhaps, and you may want to sue. You can't, okay? Please. Please don't say after today's free lecture, you say, well, this law lecturer, David from BAC says I can sue McDonald's because my burger was not so juicy. Please don't say that. I want to be very accurate now. This is an example or an illustration. But the illustration is one that allows me now to escalate the example to now giving you this further instance or situation that are we therefore seeing that advertisements can be misleading? Are we saying that a vendor can say whatever they want to misrepresent and then later say it's just an advertisement? Surely not, right? Especially in the context of online transactions. Now, I get it. That in the context of, say, food, the packaging of food, we may not get what we see. But online transactions, and many of us today now buy things online, and you would check, the description, you read the specifications, the measurements, dimensions, color, you have a picture, you blow it up, you examine from 3D point of view to see, well, this looks good, I want to buy this. Or perhaps now, it could be on Carousel. This could be a second-hand item. And this could be something now, again, you want to make sure that there are no scratches. And they say that, right? In the Carousel post, this advertisement, no scratches, unused, perfect condition. And you see the picture, it looks great. You buy, but it's not unused. There are scratches. What are your remedies? What can you do? Can the contract still remain enforceable, or can we try to now get out of a contract? What are some factors? And there are about 5 factors. Not just the part about misleading advertisements. There are other situations in our syllabus that we'll examine that allows us now to get out of a contract to say this contract was made as a result of a misrepresentation. This was made as a result of a misleading statement and will not be enforceable against me. I can don't pay you and I want my money back. I want a refund perhaps. And that's all right as well, right? In the study of contract law. The last part of our syllabus is where we want to talk about performance of a contract and the discharge of a contract. Now, if a contract had been performed, I suppose there's no issue. The issue is when the contract is not performed. When one party is either unable to or is performing the contract as agreed. And right now, because of COVID-19, we are seeing, and I foresee this, in the months ahead, in the years ahead, we will be seeing a lot of possible claims of parties asserting or suing for non-performance of a contract. Now, where if I sue you to say, hey, you are not performing the contract, then the other party being sued may say, oh, that's because of COVID-19. I could not get my supplies from Malaysia. I could not get the staff or the workers to finish the job. Now, he or she, I suppose, in that regard, will have a good reason, but that's my point. The contract is now not performed, and we want to study in this part of the syllabus, what are our rights? What is the consequence? Now, I suppose being COVID-19 and because of all the current circuit breaker rules, it may not amount to a breach or a non-performance of a contract that results in a contractual liability. But what about post-circuit breaker? In a real life situation, is it not true that sometimes parties are unable to perform their contractual obligations due to unforeseen events, due to events outside their control? Now, so when that happens, when due to events that is outside your control, due to some kind of business contingency that occurs and a contract is now not performed, breach of contract, so to speak, what are your rights? what are your remedies? Right? And that is the fourth and our final part of the syllabus. So in a nutshell, I've now given you in 5 minutes, literally, right, our A to Z of the syllabus for contract law. Okay, and so even in the use of all my examples, you may notice that many of my examples are situations that you can relate to, like signing a contract, like downloading an application, like terms and conditions, misleading advertisements, and that is really how your exam questions will be like. Your exam questions are contract situations that we go through. And a study of contract law will allow us now to know what the law says and how to respond to the situation. So contract law is a great subject and extremely practical. Now, allow me now in say 3 or 5 more minutes, right? And we'll wind down this session to talk about the first part, talk about formation of contract. And as I said, this is the beginning part of the syllabus. And some of the issues that we want to deal with would be, for example, things like, well, what about an email agreement? As in, that at the process of the email stages, the parties have been corresponding for quite a bit now. I send an email, he replies back, I change something, he responds back, then I say okay, then he says okay. Both parties say okay. Now at that stage, when we agree, is that a binding agreement? At the stage when we agree, has a contract been formed, right? And so that is something we deal with in real life, and there are real cases. There's something we study also in our syllabus on this particular topic of formation of contract. What about this then, right? That maybe now we take it one next step, that you then print out that copy of the agreement, and having printed out the copy of the agreement, then you sign, because you've agreed, right? You've agreed, and as required now, you print out, you sign, and you send back. Now, but sending is different from receiving. You may post that hard copy back to that party, but it could be lost in the mail. The dog could eat the particular contract. And so what if the postal or that posted document does not arrive and does not receive? Now, I am sure, depending as to which side you're on, the sender will say, well, I have done all I should, I've sent back. There should be a contract at the time when I send. But the recipient will say, why should there be a contract? I've not received. And so these are just some amongst many other situations that we deal with and where we study the various laws concerning this issue of formation of contract. Now, I want to give you something practical today, and so that at least you literally have a free lesson, regardless whether you enroll with us for our law courses. Today's session is where we really want to provide you with some value add, that you know something about law, about a Magna Carta, about, say, for example, offenses against the persons, criminal law. And now, formation of contract, and at the very least now you benefit something for staying on with us for so long, right? And so this is now that value add, the content of what it takes in order for a contract to be formed, where there are 4 requirements. The first is easy. There must be an offer made by one party to the other that corresponds with the other party accepting it, in which case it is not wrong to say that now there is an agreement. Offer acceptance does give rise to an agreement. But whilst there may be an agreement, it is not a contract. So whilst every contract is an agreement, not every agreement is a contract. In order for that which you agree, your agreement to be a contract, there are 2 other requirements to be satisfied. And number 3 is that something must have been given in consideration for your agreement. So in consideration for the agreement, I must have given you something. I use an easier word, price. There must be some kind of price given toward that agreement. And also, to be accurate, I've put the word price in a quote. Don't think of price as in just limited to money, cash. Yes, that's something you give towards the agreement. And very often for most contracts where it's money, payable or paid, but it's price. Because this is not just money, but money's worth. Something which the law recognizes to be of value. So long as it's something of value, whether money or otherwise, money or money's worth, something of value you've given in consideration toward the agreement, that's it. Now you're one step closer to the formation of contract. And the last requirement is that there must be an intention to create a legal relationship. Not just your casual, frivolous, social, domestic, personal, private kind of agreements that you make with your friend. I agree to buy you bubble tea every day. Now, your friend may agree to buy you bubble tea every day. He does not. Can you sue him? I agree to give you extra coaching lessons to brush up on your tennis, on badminton. Now, a friend that agrees to give you coaching, help, or services, but does not do so. If she has agreed, you have turned up, he does not show up. Can you sue him? Now, my last two examples clearly convey the idea that these are social agreements for which it lacks, number 4, it lacks this intention to create a legal relationship. And therefore, with number 4 missing, the requirements for a contract are not made out. There's no contract. But however, if in any situation that you can establish there's an offer made, that there was an acceptance to the offer, that there was a consideration provided for the agreement, and finally now together with an intention to create a legal relationship, that's it, you now have a binding agreement. And a binding agreement is your contract. And that's it, right? We have covered now what it takes for the formation of a contract. And so as we wind out the session, to answer my earlier 2 questions or scenarios concerning whether or not in the case of an email, when it's not signed, and the email that you send to each other, can there be a binding agreement? So you go back now to my earlier slide. I put down that bubble speech box, the text box that says what? Can an agreement arise from emails? Now that you have had 20 minutes of contract law, what would you think is the answer? Yes or no? Maybe just for the fun of it, if you're still watching, you can type in the chat box, tell me now. Would you think that there is an agreement? Put Y or put N. Let's have some participation, okay? Email, can it give rise to a contract? Y or N? Anyone? Before we dismiss you. Yes, thank you, Vincent. Yes, okay. If you answer correctly, correct, then you qualify to do the law program. Answer wrong, you can't join us. You fail the test. Joking, okay. No, it's just my way of trying to get you to think about these issues. And if you have listened to the past 5 minutes about the requirements for formation of contract, and thank you, Vincent, for your correct answer, because the answer is yes. So long as the requirements for a contract, they are satisfied, it's a contract. In my earlier slide, I mentioned 4 requirements. Did I say anywhere that there was a number 5 requirement? It says that a contract must be signed, must be written out, printed out. No, offer, acceptance, consideration, intention. That's it. So thank you, Vincent, for your answer. Right? And of course, the other one was concerning the acceptance that you post. There's this very antiquated rule in England called Postal Rule. And a postal rule by label or in name refers to that literally, postal rule, that upon the posting of an acceptance, it can give rise to an agreement. We don't care whether the other party has received or not. We don't care if the letter was lost. But if I posted, that's it. There is acceptance, and potentially there could be a binding agreement. Now, this is a rule that not many people are aware of. And I suppose it's part of the reason why a study of law is important. We want to know our rights for ourselves personally, for our businesses. We want to be able to safeguard our interests, to manage our legal risks. Contract law is really, really something which is important, a subject which I truly believe that you'll find extremely relevant, right, for yourselves and for your work.
The world is changing exponentially. Humanity will see more changes in the next 20 years than it has in the past 300. What we do will change. How we do it, even more so. Be ready. Join the education revolution designed to impact and transform lives. Access 300 world-class programs in over 40 areas of study from over 30 international partners and affiliates in an education ecosystem like no other. Become a future-proof global graduate now. Own your future.